Hi everybody, it's Andy and welcome to my office in Modesto, California. I'm an attorney licensed to practice law in California as well as New York. This video right now is going to go over the California answer to this question. If you saw the title to the video and you're thinking, oh wow, hey, that's exactly what I want to find out, but you live outside of California, this video does not apply to you. However, if you live in New York, I have a New York equivalent video that I'm going to link right here. So go ahead and take a look at that if you are interested. So the video today is going to go over a myth, I guess you want to call it, a rumor, misinformation, whatever you want to call it. It's basically a question that I encounter quite frequently that goes something like this. Andy, I live in California, I've lived here for years, California is basically my home. The problem is, I didn't get married here. I got married in Tennessee, Vietnam, China, wherever it happens to be. I didn't get married in California, so doesn't that mean I can't get a divorce here? And the answer to that question is no. You can get a divorce in California regardless of where you actually got married, provided you meet two requirements. And these two requirements are where the California, kind of New York or California other state sort of distinction applies. In general, this idea of a residency requirement exists in quite a few states, I think. I haven't surveyed it, but I think it exists in multiple states, except the actual requirement that each state imposes is going to be different. If you want to take a look at the New York version of this video, you'll find that the residency requirements in New York versus California are actually quite different. So that said, I'm going to go over the two requirements for California. The first one is that you have to have lived in California for the 6-month period immediately preceding the filing of your case. So to give you an example, let's say you file for divorce in California on July the 1st. That basically means you have to have lived in California for all of June, all of May, all of April, all of March, all of February, and all of January. If you don't, if you don't satisfy this criteria, you can file for something in California called legal separation. And I have a separate video, which I'm going to link right over here, that basically goes over what legal separation is. So go ahead and take a look at that if that applies to you. So anyway, that's the first criteria. You have to have lived in California for 6 months preceding the filing of your case. The second criteria is that you have to have lived in the county in California that you file your case for the 3 months preceding the filing of your case. So for example, if you live in Santa Clara County, Merced County, Los Angeles County, whatever it is, you have to have lived there for 3 months before you can file your case in that county. So that's basically it. Two criteria: 6 months in the state of California, 3 months in the county in California in which you file your case. If you meet those two criteria, you can get divorced here regardless of whether or not you actually got married in California. A lot of people think they have to go back to wherever it was they got married in order to get a divorce. I personally don't understand where that kind of impression comes from, but that's a version, I guess, of understanding that I encounter quite frequently. So, again, my name's Andy. I'm an attorney licensed to practice law in California. For those of you who are interested, I'm going to go ahead and link the California statute in question. It's California Family Code Section 2320A that I just went over, so go ahead and take a look at that if you are so interested. But yeah, hopefully that helped, and I will see you guys next time. Thanks.